Hello, my name is Lee Ryder Coffin with Miller Johnson. I'm Senior Immigration Counsel, and I'm here to give a 5-minute message covering schools and immigration enforcement for educators.
With the changing U.S. presidential administration and changing immigration priorities, it's expected that we will see increased immigration enforcement and that this may impact schools, both K through 12 and higher education. It's possible that schools may start receiving inquiries by immigration enforcement officers, including in-person visits. Up until recently, under the Biden administration, Homeland Security had issued guidance to immigration enforcement officers that schools are considered protected areas. This directed officers not to conduct in or near schools, either to do arrests or searches, seizures, subpoenas, interviews, surveillance, or the like, except in limited circumstances. Previous to 2021 and over the past decade, we saw that former versions of such guidance memos supported some limited enforcement activities on school grounds, such as to serve subpoenas and certain Homeland Security compliance visits to obtain records from schools who participate in international student programs. So what should schools do if immigration officers make contact? Well, schools should have action plans in place that comport with their state and federal law and also their district policies. Schools should work with their district superintendents and general counsel and engage legal counsel where needed to develop these plans if they don't already exist or if they need review and updating. So, for example, an officer comes into the school. Who handles that? How? What is the protocol or response? Before we can answer that, schools, specifically K through 12 public schools, are required to provide public education regardless of immigration status. This is the law following a U.S. Supreme Court decision, Playa versus Doe, in 1982. Also, certain federal laws such as FERPA, Family Educational Rights and Privacy Act, protect student educational records and personal information. And the Fourth Amendment of the Constitution protects against unreasonable searches and seizures. States also have applicable laws and protections for civil rights and access to education, such as Michigan's Elliott-Larsen Civil Rights Act. So the objectives of immigration enforcement and the objectives of school responsibilities to ensure education and privacy are a complex and difficult balance. So schools should have policies so that requests for access and/or information receive very careful review and comply with all applicable law. For instance, if a school released a protected educational record and personal information where not required by law, it could implicate privacy violations. On the other hand, if the school does not comply with a court order or a judicial warrant, then they would be violating other law. So if an officer shows up and asks for information, how should that be handled? Well, it really depends who is making the request, what agency, and on what basis. Is it an Immigration Customs Enforcement officer for Homeland Security requesting information on an F1 student visa holder record? Exceptions apply there. There are also certain time limits to provide that information on the certain type of request. So these requests should also be reviewed for scope and validity and jurisdiction. Also to consider, is the inquiry coming from an officer who shows a badge, but they're from the FBI? That's a different inquiry. That's Department of Justice involving criminal investigation. That's not DHS, Homeland Security, Immigration Enforcement, so that raises a different analysis. School superintendents and their offices of general counsel should have policies and protocols to review all requests to make a decision on whether or not the law requires or restricts providing information or access in these situations. So first, policies are the first matter to have in place. But second, schools need to have procedures in place to implement the policy. When the officer arrives, typically they're going to be interacting with the very first person, the service professional at the front desk. So what is the policy or the protocol to handle that? Are there procedures? Are there intakes so that they can clearly ask for agency, badge number, photocopy documents, and have a protocol not to release information and not to disclose until the appropriate decision maker is reviewing it? And third, there really needs to be a suitable training so that any of the people receiving information, especially frontline staff, are aware of the policy and the protocols to make sure that it is promptly relayed to the appropriate decision maker and general counsel, so there can be timely review of these matters that are compliant with all relevant law.
Thank you for tuning in and feel free to reach out if we can help.